Hello and welcome to LiveLaw Daily, your daily briefing on the most important legal developments from India's courts. It's Monday of May 25th and we have a few really important updates for you. So let's get into it. For our first story here, the Supreme Court took up a public interest litigation that shines a light on a corner of child exploitation that does not get enough attention. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice Vipul Pancholi issued notice to the Union government on a petition filed by the Just Rights for Children Alliance. Senior advocate H.S. Fulka appeared for the petitioner. The CJI called it a serious issue. The petition seeks a direction to the central government to use its powers under Section 4 of the Child and Adolescent Labour Act to expand the list of occupations where child employment is outrightly prohibited. This is to include orchestras, dance bars, dance troupes, naughty performances, massage parlors, spas and salons. Currently, some of these in Entry 52 of the Constitution, like massage parlors, sit in Part B of the schedule, meaning they're regulated but not banned. The petitioner wants them moved to Part A, which would impose a complete prohibition on child labour practices. The petition also asks the National Commission for Protection of Child Rights to put in place a standard operating procedure for rescuing and rehabilitating children found working in such establishments. Notice has been issued and the Union government will now have to respond. And in our second story, the Supreme Court's recent direction allowing euthanasia of rabid and dangerous stray dogs or community dogs has sparked a fresh controversy, this time over how local authorities are interpreting it on the ground. An NGO called Animals Are People Too moved the Supreme Court, expressing alarm that its May 19th order was being misread as a license for indiscriminate culling of dogs. Advocate Anil Kumar Mishra, appearing for the NGO, flagged a specific trigger. Punjab Chief Minister Bhagwant Mann had publicly stated that the Supreme Court had given a free hand to kill all the dogs. Media reports also pointed to dogs being removed from Khalsa College. The NGO's core concern is that the animal birth control rules of 2023 do not clearly define what counts as an aggressive dog, leaving local authorities free to slap that label on ordinary strays and cull them without any expert assessment. It sought a direction requiring a committee of a government veterinary doctor, an animal welfare representative, and a local authority official before any dog can be declared aggressive. A bench of Justice Vikram Nath and Justice Sandeep Mehta was unmoved, however. Justice Vikram Nath's response to the Punjab Chief Minister's public statement was direct. As he said, if the Chief Minister makes a statement, does that mean we need to change our order? The court refused to entertain the application and directed the NGO to approach the Punjab and Haryana High Court instead. To read all the reports related to the stray dogs matter, visit LiveLaw.in. And for our third story here, we have a brief update from the Delhi High Court today in a case involving the Wire's founding editor, Siddharth Varadarajan. To recap, Varadarajan had challenged the central government's refusal to convert his Person of Indian Origin card to an OCI card. An OCI card is an Overseas Citizen of India card. The Delhi High Court had earlier found him prima facie guilty of suppressing material facts, specifically bail conditions imposed upon him by the Allahabad High Court in 2020, which required him to not leave India without prior permission from the trial court and to surrender his passport. He had not disclosed these conditions in his plea. The High Court had recalled its earlier order in his favour and asked him to file an affidavit explaining his conduct. Today, before Justice Purushendra Kumar Kaurav, Varadarajan's counsel, Senior Advocate Nithya Ramakrishnan, confirmed that the affidavit had been filed. The centre then sought time to respond to it. As the petitioner's side pushed for an early hearing date, the court was candid about it and said it's not possible. The matter is now listed on July 15th. And for a fourth story, we have an update from the NEET-UG 2026 matter. Over 23 lakh students sat for NEET-UG 2026 and the exam had to be cancelled, as you know, because of a paper leak. And today the Supreme Court made it clear that it is not just disappointed, it is troubled by what this says about the National Testing Agency. A bench of Justice P.S. Narasimha and Justice Alok Aradhe heard petitions from the United Doctors Front and the Federation of All India Medical Association, both seeking the dissolution or fundamental restructuring of the National Testing Agency following what they called its systematic failure. Justice Narasimha's remark from the bench was pointed. He said, "We are so sad and they haven't learned their lessons." He continued to say, "We passed an order directing the constitution of a committee to give recommendations, which was accepted. That committee was the high-level committee chaired by former ISRO chairman Dr. K. Radhakrishnan, which was formed after the 2024 NEET paper leak. The Supreme Court had directed it to recommend reforms across examination security, CCTV surveillance, candidate verification, encryption, and real-time monitoring too. The National Testing Agency filed a compliance report in December 2024 last, and today it's May 25th. Today, the court directed the National Testing Agency to file an affidavit within 3 days on the status of the monitoring committee constituted on November 14th, 2024. Dr. Radhakrishnan himself has been asked to file a separate affidavit on compliance steps. The petitioners are asking for a parliament-enacted statutory body to replace the National Testing Agency entirely, with direct accountability to the legislature. For our fifth story, we have a long pending case of brutal mob violence which finally saw its sentencing chapter close today at the Kerala High Court. Madhu was a mentally challenged tribal youth from Palakkad. In February of 2018, he was caught stealing rice from a grocery shop and was lynched to death by a mob. It became one of the most disturbing cases of mob violence in recent memory. A division bench of Justice Raja Vijayaraghavan and Justice K.V. Jayakumar today sentenced 12 of the convicts to life imprisonment. They were found guilty under Section 304 Part 2 of the Indian Penal Code, that is for culpable homicide not amounting to murder, along with charges of grievous hurt and kidnapping, all read with SC/ST Prevention of Atrocities Act, which carries a mandatory life sentence. The first accused, who was Hussain, he was acquitted. The court maintained the Sessions Court's imprisonment terms for the lesser offences under Sections 143, 147, 323, 324 and 342 of the Indian Penal Code, but modified them to be read in conjunction with the SC/ST Act. Each of the 12 convicted persons has also been directed to pay fines ranging from Rs 15,000 to Rs 2 lakh with default imprisonment for non-payment. The Cockroach Janta Party controversy is our sixth story here. It began with oral remarks by Chief Justice of India Suryakant during a Supreme Court hearing, where reportedly he compared unemployed youth turning to online activism to cockroaches. And this took another turn today. Advocate N.K. Goswami mentioned a petition before the Chief Justice of India concerning the issue, submitting that despite the Chief Justice's own clarification that his remarks were directed at those entering professions with fake degrees, a distorted and malicious narrative was continuing online. The Chief Justice of India's response to that was, "Don't take it so sentimentally." Separately, another petition was also mentioned for urgent listing, one seeking a CBI probe into the commercial exploitation of those courtroom remarks. That petition argues that an out-of-context clip of a courtroom exchange was turned into branding, trademarked, monetized and circulated as digital spectacle. And this petition seeks action against fake advocates, referencing the Bar Council of India chairperson's recent statement that 35 to 40% of the advocates in India are fake. The social media handles of the Cockroach Janta Party, which had amassed millions of followers within days, were subsequently suspended too. The Chief Justice of India said there was no urgency in the matter and it would be listed in due course. And for a seventh story here, which is equal parts procedural and human. A man in detention in Junagadh filed a habeas corpus plea before the Gujarat High Court this morning, pointing out that he had been detained since May 24th. That was just one day before the election for the chairman and the vice chairman of the Junagadh Taluka Panchayat. He wanted to cast his vote here. The state pushed back, however, as the FIR against him was from May 22nd. The petition was belated and the offences were serious enough that no leniency was warranted. Justice D.N. Ray noted something else entirely. The matter had been mentioned at 9:30 a.m. The court had directed the file to be sent immediately and the file arrived only at 11:45 a.m. 2 hours and 15 minutes later, after the scheduled election time had already passed. Despite that, the court passed an interim order. It directed that the detainee be escorted by police to the venue of the election, cast his vote and return directly to the detention center. The election was to remain open until that process was completed. The post of the chairman and vice chairman of a Taluka Panchayat is an important position. Even a single vote may swing the contest one way or the other. The matter is now listed on June 10th. And for our eighth story, we have the Punjab municipal election in the center, as the Supreme Court today dismissed a petition challenging the use of ballot papers instead of electronic voting machines in Punjab's municipal elections scheduled for tomorrow. A bench of Chief Justice of India Suryakant, Justice Joy Malia Bagchi and Justice Vipul Pancholi refused to interfere. The CJI's position was straightforward, as he said that elections are tomorrow, arrangements are made and there is simply no time left. But the reasoning from Justice Bagchi is worth noting here, as he made clear that the State Election Commission is the ultimate authority in conducting state elections, and ballot papers have not been removed from the legal framework governing municipal polls. The State Election Commission had the power to choose between ballot papers and EVMs and exercised it. When senior advocate Nachiketa Joshi pointed out that the Supreme Court had itself described reverting to ballot papers as a regressive step, Justice Bagchi acknowledged it, but said that since the election process had already begun and the rules did not exclude ballot papers, the court would not second-guess the State Election Commission's decision. There was no jurisdictional error. The request to appoint election observers was also turned down, as the court refused to presume that the elections would be unfair. The special leave petition, which challenged the Punjab and Haryana High Court's earlier refusal to stop the ballot paper elections, stands dismissed. That's LiveLaw Daily for Monday, and I will see you tomorrow again with the most important stories from India's courts. Like, share and follow LiveLaw on all our socials to stay updated with everything that is law.